Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Krish Jain. He is going to speak on discharge and breach of contract. He is from KES Sri Jayantilal H. Patel College of Law. So without wasting further time, I would request Krish to commence with his lecture. Thank you.
A very good afternoon to one and all. My name is Krish Jain and I'm here to talk about an important topic, an essential element in the corporate world, that is the provisions of discharge and breach of contract and its remedies according to the Indian Contract Act 1872. Before understanding the provisions of discharge and breach of contract, let us understand the meaning of contract. What is contract? According to Section 2H of the Indian Contract Act, an agreement enforceable by law is contract. What is an agreement? An agreement when a proposal is made by one party to the other for mutual consideration and that the other party gives its acceptance, hence forming an agreement. In short, offer plus proposal plus acceptance is an agreement. When this agreement gives rise to legal obligation or is legally enforceable, then it is known as a contract. Before coming on to the main topic of the video, there are few terms which are required for you to understand. These terms include the principle of novation, alteration, recession, and remission. Firstly, novation. It means when parties to a contract substitute a new contract for the old one, which means all the parties included in the contract mutually decide to substitute a whole new contract in the place of old one. This new contract can have completely new terms or may even be formed by new parties altogether. The old contract is said to be discharged and consequently its provisions need not be performed. Novation can take place only if there is mutual agreement between all the parties to the contract. Let me give you an example. A owes B a sum of 1 lakh rupees. A, B and C mutually agree that C will pay and B will accept those sum of 1 lakh from C and the due sum due from A. Therefore, A's liability thereby shall come to an end and the old contract between A and B will be substituted by the new contract between B and C. Then comes alteration. Alteration in terms of contract happens when the parties enter into a contract and one of the party wants to modify or change certain terms of the contract with the assent of the parties. Hence, once parties sign the contract, they cannot alter the terms except in the case where all the parties by the mutual consent agree to the alteration. For instance, a change in the date or place of delivery in the contract of sale of goods between parties. Distinction between novation and alteration is very slender. In the case of novation, the parties to a contract may change, but in the alteration, they will remain the same. Secondly, in novation, the existing contract is substituted with a new one, but in alteration, there is no substitution of a new contract. Only certain terms and conditions of the contract changes. Third, principle of recession. Recession means to rescind, to cancel or to revoke something. Under the contract law, it means a party to the contract can cancel or terminate the contract. In this, the parties legally terminate a contract by mutual agreement or mutual consent. Under Section 62 of the Indian Contract Act, a party is allowed to rescind a contract, but such rescission should be only by bilateral terms. Lastly, the principle of remission. It occurs when the parties to a contract accept a lesser amount or a lesser degree of performance than what was initially agreed upon the performance. Under Section 63 of the Indian Contract Act, it states that a party may remit the performance started wholly or in part, extend the time for performance, accept any other kind of performance apart from the one mentioned in the contract. Now let us come to our main topic, the discharge of contract. A contract is said to be discharged when the obligations created by it come to an end. There are various ways in which a contract can be discharged, and those include firstly, discharge by performance. It means when the parties to a contract fulfill their obligations arising under the contract within the time and the manner prescribed. Discharge by performance can be of two types. Firstly, actual performance. It is said to have taken place when each of the parties has done what he had agreed to do under the agreement, unless the Indian Contract Act or any other law for the time being prohibits the parties from performing their performance. Secondly, attempted performance. When the promissory offers to give his performance under the contract, but the promisee refuses to accept the same, then it amounts to be discharged by attempted performance. Secondly, the discharge comes by mutual agreement. In this, the parties to a contract do not perform the promises stated in the contract if they arrive at a mutual agreement. This requires substituting or altering and existing the new contract with a new one. Discharge by lapse of time. A contract should be performed within a specific period as prescribed under the Limitation Act 1963. If it is not performed within that duration, the contract will be discharged. If no action is taken by the promisee within the specific period of limitation, he would be deprived of remedy by law. For example, if a creditor does not file a suit against the buyer for recovery of the price within 3 years, the debt becomes time barred and hence irrevocable. Discharge by operation of law. This mode of discharge of contract does not allow the fulfillment of the promise laid down in the contract by the provisions of law. Situations such as death, insolvency, merger, etc. do not enable the fulfillment of the promise, hence it results in the discharge of the contract. Fifth, discharge by waiver. The term waiver means the abandonment of a right. A party to a contract may have their rights specifically stated under the contract, which also helps to release the other party from the contract, and the contract is discharged. Discharge by supervening impossibility. It means contract that has become impossible or illegal to perform. In these cases, the contract becomes void. It is known as the doctrine of frustration. Frustration occurs when it is established that due to subsequent change in circumstances, the contract has become impossible to perform. The ways in which it could occur is unforeseen change in law, destruction of the subject matter, that is an essential element of the performance, declaration of war on account of death or personal incapacity. Seventh comes discharge by breach of contract. When contracting party refuses or fails to perform or disables himself from performing or makes the performance of the promisee stated in the contract impossible by his conduct, then the contract is said to be discharged by breach. A party to a contract may discharge it by actual breach or anticipatory breach. Discharge by merger of rights. Sometimes the inferior rights coincide and meet in one and the same person. In such cases, the inferior rights merge into the superior rights. On merger, the inferior rights vanish and are not required to be enforced. For instance, A took a land on lease from B. Subsequently, A purchases that very land. Now A becomes the owner of the land, and the ownership rights being superior to the rights of a lessee, the earlier contract of lease stands terminated. There is a very important case law with regards to discharge of contract, that is Dharamveer versus State of Uttar Pradesh, AIR 1979, SC 1518. A contract for construction work was discharged because new government regulations prohibited the use of certain materials. The contract was held to be frustrated due to the legal impossibility, hence it was discharged by supervening impossibility. There are some exceptional cases when a contract is not discharged. The doctrine of frustration or supervening impossibility does not apply to the following cases mentioned below. When, in any case, a situation arises that makes the performance of the certain promise mentioned in the contract very difficult to be performed, then in that situation it makes the promise challenging to be fulfilled, but the contract is not discharged. Commercial hardships commercial hardships make the contract unprofitable, but it does not discharge a contract. Strikes, lockouts, civil disturbances, and riots do not discharge the contract unless there is a clause in the contract specifying that in such event the contract will be terminated. Fourth, a contract is not discharged due to the self-induced incapacity of the parties to a contract. In a contract where performance is relied upon by a third party, it will not be discharged due to the failure or default of the third party. Now let's come to the last topic of this video, breach of contract and its remedies. Breach of contract and its remedies. What do you mean by breach of contract? A contract can be said to be breached or broken when either of the parties fails or refuses to perform his obligation or his promise under the contract. Therefore, it can be said that when a binding agreement is not honored by one or more parties by non-performance of his promise, the agreement can be said to be breached. This breach may arise in two ways. Firstly, anticipatory breach. An anticipatory breach of contract is a breach of contract occurring before the time fixed for performance has arrived, when the promisor refuses altogether to perform his promise and signifies his unwillingness even before the time of performance has arrived. It is called anticipatory breach. Anticipatory breach of contract may take either of the following two ways: expressly by words spoken or written, and impliedly by conduct of one of the parties. Effect of anticipatory breach: the promisee is excused from performance or from further performance. Further, he gets an option to either treat the contract as rescinded and sue the other party for damages for breach of contract immediately without waiting until the due date of performance. Secondly, he may elect not to rescind but to treat the contract as still operative and wait for the time of performance and then hold the other party responsible for the consequences of performance. But in this case, he will accept the contract alive for the benefit of the other party as well as his own, and the guilty party, if he so decides on reconsideration, may still perform his part of the contract and can also take advantage of an supervening impossibility which may have the effect of discharging the contract. Secondly, actual breach of contract. An actual breach of contract refers to a breach that has actually happened, indicating that the breaching party has either refused to fulfill their responsibilities by the due date, or has executed the duties badly, or has left them incomplete. When a breach occurs, the opposite party has numerous options for resolving the situation. For example, on July 21st, 2018, Mr. X signs a deal with Mr. Y, pledging to deliver 50 bags of jute to him. However, he fails to deliver on the designated day. This is a clear case of an actual breach of contract. Types of actual breach of contract. Actual breach of contract due to late performance. This occurs when the parties fails to meet contractual duties and obligations within the specific period of time and conformance. In such cases, the other party is not obligated to fulfill their obligations and can hold the defaulting party liable for the breach of contract. However, if time is just a minor factor, or if time is not as important requirement, the aggrieved party may accept performance and seek damages for late delivery. Actual breach of contract during the course of performance. It refers to a party's failure or reluctance to carry out the contractual duties during the course of their performance. It can also happen if a party fulfills its responsibilities but refuses or fails to comply with the contract's key terms and conditions. Remedies for breach of contract. Under Section 73 of the Indian Contract Act 1872, when a contract is broken, the party who is aggrieved by the breach is entitled to receive compensation for damages from the party who has broken the contract. The damages must have naturally arisen in the normal course of things from the breach, of which the parties knew when they made the contract to be likely to result from the breach. The damage is only payable if the loss was caused by the breach according to the Section 73 of the Indian Contract Act 1872. There are no damages if there is no loss as a result of the breach. Compensation is not paid for any remote or indirect loss or damage sustained because of the breach. Remedy by way of damages. Remedy by way of damages is the most common remedy available to the injured party. This entitles the injured party to recover compensation for the loss suffered by it due to the breach of contract from the party who causes the breach. Section 73 and 75 of the Contract Act incorporates the provision in this regard. The damages which may be awarded to the injured party may be of the following kinds. Ordinary damages. When a contract has been broken, the party who suffered by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, which the parties know when they made the contract to be likely the result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by reasons of the breach. Second comes special damages. When a party to a contract receives a notice for special circumstances affecting the contract, he will be liable not only for damages arising naturally and indirectly from the breach but also for special damages. Vindictive or exemplary damages. These damages may be awarded only in two following cases. for breach of promise to marry because it causes injury to his or her feelings, for wrongful dishonor by one party to another as it causes loss of credit and reputation to the parties. Third comes nominal damages. Nominal damages are awarded when the plaintiff has proved that there has been breach of contract but he has not in fact suffered any real damage. It is awarded just to establish the right to decree for the breach of contract. The amount may be a rupee or even 10 paise. Damages for deterioration caused by delay. In this case, deterioration caused to goods by delay, damages can be recovered from carrier even without notice. The word deterioration not only implies physical damages to the goods, but it may also mean loss of special opportunity for sale. Prefix damages. Sometimes parties to a contract stipulate at the time of its formation that on a breach of contract by any of them, a certain amount will be payable as a damage. And these amount can be either liquidated damages, that is reasonable estimate of the likely loss in case of breach, or a penalty, that is amount arbitrarily fixed by the damages payable. Section 74 provides that if a sum is named in contract as the amount to be paid in case of a breach, the aggrieved party is entitled to receive from the party at fault a reasonable compensation not exceeding the amount so named. Remedy by rescission of contract. When among the parties commits a breach of contract, another party shall additionally treat the contract as void or cancelled. Once the contract is cancelled, the affected party is mechanically discharged from all the commitments beneath the contract. Section 64 of the Act provides that the party cancel the contract if he has received any profit under it from the opposite party, restore such profit to the person from whom it has been received. Further, the one that truly cancels the contract is entitled to compensation for any loss that he has faced from the non-fulfillment of the contract. Remedy by quantum merit. Quantum merit literally translates to as much is earned. At times, when one party of the contract is prevented from finishing his performance of the contract by the other party, he can claim quantum merit, so he must be paid a reasonable remuneration for the part of the contract he has already performed. This could be provided on or the value of this could be provided on the basis of the value of work he has already done. For the application of this doctrine, two conditions must be fulfilled. It is only available if the original contract has been discharged. Secondly, the claim must be brought by a party not in default. Remedy by suit for specific performance. This means the party in breach will actually have to carry out his duties according to the contract. In certain cases, the court may insist that the party carry out the agreement. So, if any of the parties fails to perform the contract, the court may order them to do so. This is a decree of specific performance and is granted instead of damages. For example, A decides to buy a parcel of land from B. B then refuses to sell. The courts can order B to perform his duties under the contract and sell the land to A. Remedy by suit for injunction. An injunction is basically like a decree for specific performance but for a negative contract. An injunction is a court order restraining a person from doing a particular act. So, a court may grant an injunction to stop a party of a contract from doing something he promised not to do. In a prohibitory injunction, the court stops the commission of an act, and under mandatory injunction, it will stop the continuance of an act that is unlawful. For example, N, a film star, agreed to act exclusively for a producer for 1 year. During the year, she contracted to act for some other producer, held she could be liable and restrained by an injunction. There is a very important case law regarding the breach of contract. It is Hadley versus Baxendale 1854. In this, a mill owner contracted a carrier to deliver a broken shaft to a manufacturer for repairs. Due to the delay, the mill was unable to function and the mill owner suffered a loss. The owner sued for the losses. In this, the court held that for damages to be recoverable for a breach of contract, the loss must be foreseeable at the time of the contract was made. The principle of remoteness of damages was established, meaning damages would only cover losses that were reasonably foreseeable at the time of contracting. In conclusion, the breach and discharge of contract are critical concepts in contract law and determine the rights and obligations of parties involved in an agreement. Discharge refers to the termination of contract which can occur through various means such as performance, mutual agreement, or frustration. On the other hand, a breach occurs when party fails to fulfill their contractual duties, leading to potential legal consequences. Ultimately, understanding both discharge and breach along with their corresponding remedies is essential for maintaining fairness and accountability in contractual relationships. Legal mechanisms in place ensure that parties are protected and can seek appropriate compensation or enforcement whenever necessary.
Krish, thank you very much. It was a nice overview of discharge and breach and the various things which you had explained in this particular lecture. So, thank you very much. A small token from Hammurabi to you.
Thank you so much.